8:06, Wednesday's Good Morning Scotland with Laura and Gary. As we've been reporting, Scotland's criminal justice system stands on the brink of seismic change. The Scottish Government is set to unveil a new bill proposing radical reform in our courts. Among the changes, an end to the centuries-old third verdict. Jurors will no longer have the option to judge any case not proven. And it's being suggested there could also be plans to end the involvement of juries in rape trials. Well, Sandy Brindley is the Chief Executive of Rape Crisis Scotland. She's here alongside the leading defence lawyer, Tommy Ross, KC. Good morning to you both.
Good morning.
Good morning, Gary.
Sandy, first of all, would you welcome the moves that we've just talked about there?
I think this is a really positive development. We know there's significant issues in the response to sexual crime in Scotland. Rape has got the lowest conviction rate of any crime type. The process is extremely traumatic for complainers. So Lady Doreen, the second most senior judge in Scotland, carried out a review that reported 2 years ago that made a number of changes that could really transform legal responses to rape in Scotland. And I hope to see many of these changes in the bill that's been released today.
And are you convinced that this low conviction rate that you've mentioned there, and has been the case for a very long time, is down to how the criminal justice system works, as opposed to perhaps particular difficulties in proving sexual crime cases?
There can certainly be challenges in proving sexual crime cases, but I have seen not proven verdicts in particular in cases with what seemed to me to be overwhelming evidence. I think there are issues at every stage of our criminal justice process in relation to sexual offences. Most cases, the vast majority of reported cases, never make it to court. Of those that do, it's a much, much lower conviction rate than the average for crime across Scotland. And I don't think there's just one fix to that, but I think the proposals that are under discussion that I hope to see today, I think really could bring about a transformative change in improving legal responses to rape.
Well, Tommy Ross, is it the case that not proven is returned more often in cases of sexual offence than in other trials? And if so, why do you believe that is the case?
Well, I think it is, Gary, but it's very, very easy to understand why it's the case, because in a murder trial there might be 20 different sources of evidence, DNA, eyewitnesses, admissions, whereas in a rape trial, generally speaking, when it's a single allegation of rape, it's one person's word against another. So it's really very easy to understand why there are more acquittals in rape cases than there are in other cases.
And do you believe that also contributes to the low conviction rate that Sandy's just talked about, as opposed to she sees issues within the criminal justice system and how cases are prosecuted?
Well, I mean, I hear Sandy say this a lot. I mean, as we're having this conversation, Gary, ordinary working people, cleaners, office workers, taxi drivers will be making their way to our courts to serve as jurors. And these people will make a promise to conduct the trial properly. Sandy regularly comes on these programmes and alleges that jurors don't do their job properly. I'm a veteran of 300, 400 trials. I'm 100% confident that they do. And Sandy comes onto these programmes and basically says that juries make a promise to us that they will well and truly try the accused according to the evidence, and then they don't. That's what she's alleging, essentially.
Sandy?
Yes, I think what we all want is a system where we can be confident that the evidence that's been heard in rape trials is being assessed fairly and objectively and isn't influenced by false assumptions or attitudes towards women.
But wouldn't the accused in every case want that?
I think that's what we all want in every case, but that there is particular issues in sexual offence cases in relation to rape myths and the false assumptions jury members might bring to bear in the evidence that they hear, and that there's now overwhelming evidence that is the case, that juries are influenced by rape myths in terms of their deliberations.
Just explain to us what you mean by that.
So I think there's a lot of common sense, if you like, ideas about how somebody would react to rape, that they would fight back, so therefore there'd be significant physical injury, that they would report straight away. this enduring idea that real rape, if you like, is carried out by a stranger, like outside. And we know in the vast majority of cases that does happen, but the majority of cases do not involve significant injury. They're carried out by someone known, often a partner, an ex-partner, or friend or colleague. And I think there is just like a disjoint between jury members' expectations of the kind of evidence they're going to hear and what the reality of rape is. So for these reasons, because of the significant concerns about jury decision making in rape cases and the impact of attitudes and rape myths, what Lady Doreen recommended in her review was a pilot to try judge-led trials in rape cases. And I think there is enough concern about jury decision-making to justify that. And I'm not in any way saying that jurors go in with bad faith, but what I am saying is that there are attitudes that the members of the public hold in relation to sexual crime and in relation to women's behaviour that can be played out over the course of a rape trial. And that basically is fundamentally unjust.
And Tommy Ross, in terms of trying to improve that conviction rate, that low conviction rate that we have in rape and attempted rape cases as opposed to the overall conviction rate, is it not worth at least trying this idea of removing juries, summary justice as it were, where a judge would sit in judgment in this case, and to see what sort of effect it has?
Well, why should we assume, Gary, there's anything wrong with the conviction rate? I've never understood that. I mean, the conviction rate should match exactly the number of cases which are proved beyond reasonable doubt. And the people who work in the criminal justice system believe that that test has been met. But the people, Sandy always says that there's considerable disquiet, there's considerable concern. The only person ever here expressing any concern is Sandy. You know, I work with prosecutors every day. I don't hear them saying that they're concerned about the conviction rate. I hear it every time Sandy's invited to come onto one of these programmes.
Well, Sandy, there is a low conviction rate, that is for sure, when it comes to rape and attempted rape. May it be that, as suggested there by Tommy Ross QC, that the case is just not strong enough at times?
I mean, I think that is quite an easy approach to take to the issue of low conviction rates, to say, oh, it's simply one person's word against another. That I have never seen a rape case prosecuted in the High Court where it was simply one person's word against another. We've got a requirement for corroboration in Scotland. There must be support and evidence for a case to get to court. And I am not the only person raising these concerns. If you look at Lady Doreen's report, Lady Doreen's the second most senior judge in Scotland. She clearly thinks there's an issue if she's recommending this. There's also judges...
But your assumption it seems to be that a lot of guilty people are walking free. They're not being convicted. But how do you know that's true?
Well, there was one judge quoted in Lady Doreen's report on the review of sexual offences who said he regularly sees cases, particularly single complainer rape cases, where the jury decision is inexplicable in the face of the evidence. And I think that should concern us all, because what we know is that many women in particular are being failed by the justice system, and I have no doubt that guilty men are walking free, and I think we need to do something about that.
Tommy Ross, Casey, what happens now as regards this? This is a consultation, but we know there are many in the legal profession who share the views that you have given us this morning. Is there likely to be a backlash against this, do you believe?
Well, I mean, this First Minister, when he was the Justice Minister, tried to abolish jury trials before, and the proposal didn't last 24 hours. The backlash was such that by the time I got up in the morning, he had withdrawn the proposal. So, you know, there's every chance so far as juryless trials are concerned that will go. I mean, as recently as the Natalie McGarry case, the senior judges expressed in the appeal court their respect of what they described as the collective intelligence of a jury, and reinforced the fact that it's to be assumed that juries work according to the information they're given by the judges. Now, if our judges have faith in our juries, then I expect our judges to come out fighting for the jury system. You know, I mean, it's been abolished in Russia, it was abolished in Nazi Germany. I don't expect the jury system to be abolished in Scotland.
Tommy Ross, KC, defence lawyer, thank you for your time, and also thank you to Sandy Brindley, Chief Executive of Rape Crisis Scotland.
16 minutes.